Okay, so I've read them Bruckman, and they can participate by any objection to those plaintiffs appearing by or counterplaintiffs, I suppose. All right, Mr. Hanson.
I represent Brian Cisco and Chuck and Laura Colton, defendants and counterplaintiffs.
Okay, very good.
And they were present in the court.
Okay, very good. Welcome. And then there was Richard and Doris Reeves in pro per. And then there was a judgment entered about the claims against them, but they didn't assert any counterclaims, and they're not participating in this segment of the case. Am I correct about that?
Correct. Okay. They've been consistent.
Yes, they certainly have been. All right. And we are here for the bench trial. I do see Mr. D'Angelo in the courtroom. I presume he's a witness here today.
He'll be our first witness, yes.
Okay, first witness, so there's no problem with him being present for openings, or do you want him sequestered for that, Mr. Science?
Well, no, I don't necessarily think he needs to be sequestered. I think there are some preliminary matters I would request that we address prior to beginning trial. Okay. I did file a motion to limit damages. It was scheduled for before the trial in March, before we got snowed out.
I thought we had a hearing on that, and I ruled against you.
No, you had a hearing on the motion, their motion to amend.
To amend?
And you ruled against that.
Oh, we never did have a hearing on the motion to limit the
no, we didn't, Your Honor.
Proofs of damages? Okay.
And so, I'm sorry, Your Honor.
Well, let me tell you then, that had gotten was it noticed up and it just got canceled due to the weather situation?
Correct. It was noticed for the same day as the last trial in March, and because of the snow out.
And not re-noticed.
Well, whether we consider it a motion or objection to the real estate agent's testimony, I think the issue needs to be dealt with as to whether value is even relevant to this case.
Okay, well, this has been difficult for us to get to actually try on the substantive proofs on what I have long expressed as my view to be the, and I don't mean to diminish the party's interest in the counterclaim, but I have long viewed the counterclaim as the footnote to the case, and we have had a hard time getting to the proofs on the footnote. My notes, my pre-trial notes to myself upon reviewing your motion were these, Mr. Zayas, that I would lean toward denying it. I might well agree with plaintiffs, but since defendants have the burden of proving damages, I'm reluctant to limit their proofs too restrictively. So I think we are here today. I'd be inclined to let them present the proofs that they want to present. And then whether they carry the day or not, I frankly am fairly skeptical, and I have expressed previously my belief that I'm fairly skeptical that they're going to be able to prove anything other than nominal damages. But I think it'd be a mistake for me to restrict the scope of their proofs. Any reason why I should limit the scope of their proofs today?
Yes, Your Honor, because according to the Supreme Court case, the Kratz versus the Independent Order of Oddfellows case, for a temporary trespass, the measure of damages is the cost to repair. They don't get diminution in value. So to the extent that we have a witness that's going to testify to diminution in value is completely irrelevant, because that's not the measure of damages. The measure of damages, according to Kratz, is cost to repair. Now, if they want to present evidence that there was some damage to this property and that they had to repair it, great. I haven't seen anything to suggest that this 3-foot temporary trespass has caused damage to the property, but to the extent that they want to try to actually address the actual measure of damages according to the Supreme Court, they can do so. But to spend their time on testimony that's not the proper measure of damages, such as diminution in value and what a rental slip on Bird Lake is, we're spinning our wheels, because that's not the proper measure of damages. They're not entitled to that under the law.
All right, and Mr. Cleavorn, your response to that?
Well, I guess we're having closing arguments before we even get into the proofs, Your Honor. But,
well, not really so much that. I just want to, Mr. Zayas wants me to foreclose you even presenting that.
I understand, and I thought we went through this a couple times before, but I will reiterate the case that we cited from, it was the Pine River case where somebody was ruled that they can't trespass on property to get to a navigable area. So part of the issues here are the boats that are moored on the dock that will still intrude into the lake space. And so again, there's case law right on point that says you can't trespass, and that's what has been occurring. And so, again, we respect the judge's decision with regard to proofs for 2022 and 2023, but there was the trespass in 2024 and also last summer in 2025. And so unless we get to the importance of that and how, if that continues and we don't get an injunctive order preventing that future trespass and into the future, then we're going to have property from our view of the world is going to be diminished in value.
All right, very good. Mr. Hanson, any input?
No, I concur, but
All right, can you rebuttal argument, Mr. Sykes?
Sure. First of all, we got to look at what the Pine River case actually says, and we dealt with this when we talked about whether they can amend their complaint or not. As far as accessing, it's a case where it says you can't cross someone's property to get to the river. Well, fine, that's not what happened here. If the court looks at the survey, the actual base of the dock is on my client's property. Their argument is that it crosses over onto their bottomlands. So, and it was moved. So we're not talking about someone, accessing, crossing over someone's property to get to navigable water. It's a total red herring argument. The case is irrelevant. Moreover, he didn't address the greater argument, which was, according to the Supreme Court, the measure of damage is the cost to repair the property, not the diminution in value. Now, which is completely irrelevant. As far as an injunction goes, frankly, Your Honor, I consider an injunction to be irrelevant as well, simply because the court has already ruled that the survey is where the property line is. The court has made that ruling already. Their dock isn't there anymore. So if they cross that property line short of the Court of Appeals doing something, it's either a trespass. You can do a permanent injunction if you want. It's not going to change the fact that it's either going to be a trespass or whatever. So I think this permanent injunction question is also a red herring. The court has already ruled on the property line and that it was a trespass. If they do it again under the court's ruling, it'll be a trespass again, whether you do a permanent injunction or not. It's a total red herring to look at it that way. The question is,
perhaps the counter plaintiffs might think, well, an injunction is way better than us spending several $1,000s to start a new lawsuit where the judge might only give us $1 in damages. I'm just presuming that there's going to be some value to them for an injunction, regardless of what measure of damages we come up with for the trespass. Otherwise, your clients would be allowed to or wouldn't be allowed to legally, but they could, if they wanted to be difficult, just put it over there for a few inches and say, no, you're going to have to spend thousands of dollars to get nothing back. Whereas an injunction would have some meaningful teeth to it.
Pay very close attention here, because the judge is about to step in and completely change the tone of this hearing. What started as a small trespass argument is suddenly turning into a much bigger conversation about future lawsuits and property rights.
I understand that, Your Honor. The court can, we can have an argument over whether an injunction is appropriate equitably or not. But the real estate agent's testimony is not going to add to that. Okay. If the court feels it's equitable to do an injunction, the court can do so. It already rules this a trespass. But as far as what the value of the property is, it's irrelevant on the craft decision because the value is the cost to repair any damage that was there. And that's what we're here to talk about today. And the real estate agent doesn't lend anything to that. It's totally irrelevant.
Okay, thank you. Well, there's a motion before trial to limit the scope of the proofs as to the damages, relying on some authority from the Supreme Court that the measure of damages for a temporary or repairable damage is the cost to restore the property to its original condition. There are a number of cases at the common law from various courts that have developed over a long period of time with lots of guidance for what measures of damages ought to be for various civil and property wrongs and torts. But these are all with a mind toward helping a court to craft a remedy that will, in fact, remedy the wrong that was committed. And so I think it is incumbent upon courts to allow, a party to try to establish what they think the precise nature of the wrong was and what type of damage or measure of damage would fully repair that wrong. So I'm going to deny the motion to limit the scope of the counter plaintiff's proofs in the manner that was requested. All right, so Mr. Cleaborn, as counter plaintiff counsel, do you have an opening statement to make?
I think you probably heard enough. So we're just ready to go.
Okay. Mr. Hanson, any opening statement?
No.
Okay. Mr. Zayas, any opening statement?
Yes, Your Honor. Frankly, these are spite claims. That's what they were. They were angry, they were sued, and so they brought claims out of spite, and here we are. It's a 3-foot trespass. Now, my clients still deny that it was so, but the court has made its ruling, and until it's appealed, it is what it is. And taking that for what it is, it's less than a 3-foot trespass on the bottomland, on a corner. Now, we're not even talking 3 feet on the actual upland where we crossed into their property and went out. We're talking about 3 feet angled over onto their line. They didn't even know it was there. Asked in deposition, and I assume they'll testify in accordance with their depositions today. Did it have any effect on you? Everyone said no. And yet we're here today with all these unique legal arguments trying to get, exorbitant damages based on this 3-foot trespass. So we'll hear what the testimony is, Your Honor, but at the end of the day, I'm fairly confident that I would ask the court to enter a claim for nominal damages only. Now, we're also here today to talk about this conversion claim. You will hear, it appears from filings that were made that the strategy of the counter plaintiffs is to negate Mr. Holderman's ownership of the anchor. What this conversion complaint has is kind of this 2-part thing. It's a cement anchor with a chain that goes up and the buoy that sits on top of it. Now, what you'll hear from Mr. Holderman is that he purchased it. He used it in front of his property as a favor to plaintiffs back when people were getting along, to counter plaintiffs, I'm sorry. Back when people were getting along, he moved it over in front of counter plaintiffs' property so they could use it. He never intended to give it to them. He never intended to abandon it. What counter plaintiffs will testify to, while somewhat different, I don't think the differences are legally important, because they'll say it was there when they purchased the property and they don't know who bought it. Now, my client will actually testify that Mr. Copton asked him after everything fell apart to come get it. So he went over, he unhooked the buoy, he brought the cement anchor back, he asked Mr. Cisco, and Mr. Cisco's testimony is consistent with this, where do you want it? Mr. Cisco pointed. My client dropped it where he pointed. They still have the buoy. That's the conversion claim. They're accusing my client of converting something that he owns. But importantly, Your Honor, why I don't think the differences in testimony is legally significant is because they must prove ownership as part of a conversion claim. And I'm not breaking the ground here. They must prove ownership. Well, they can't do that. And I'll ask the court to listen for testimony that they actually own this thing. They can't do that by negating Mr. Holderman's ownership. Whether it's through this very unique theory that that's been put forth in counsel's brief about adverse possession of personal property, which doesn't exist in Michigan. The court would be creating an entirely new cause of action. Just because assuming the statute of limitations on a conversion claim that my client could file has expired doesn't make it their property. The cases don't say that. Abandonment, they have to prove actually intent. They're not going to be able to prove that. Just non-use isn't enough. And they have to, if they're trying to claim it was a gift, they have to prove intent of the gift. So they actually have to prove ownership. You're not going to hear testimony of ownership. So when we listen to the actual testimony today on both these claims, Your Honor, you're going to hear nominal damages or no damages as to the trespass, and you're going to hear a story about conversion of something that my client owns and that they can't present any evidence that their own clients actually own.
Okay, thank you. Mr. Hanson, I guess I'm having a hard time laying my hand on it right now. I just want to clarify or confirm in my mind, your client's counterclaim, does it include the conversion count as well?
Yeah.
Okay, so they're identical.
We just,
Okay. Okay. All right, so,
Me too.
okay, because you've been, I have sort of taken the approach of having Mr. Cleveland go first and then checking with you. Is that fine for order of proofs today as well?
It is.
Okay.
He's leading and I'm happy that he's leading. And,
Okay.
I'm trying to support.
You before age.
Okay, all right, well, Mr. Cleveland, with that, your first witness, please.
Yes, I believe council would agree that proposed exhibits 1 and 2, that would be for the record, the plat map of Vincent's Ridge and the survey would be a bit of a stipulation.
So exhibits 1 and 2 are absent objection, they're already marked, are received and.
It'd just be easier for you to follow, I hope.
Okay, thank you, and admitted into evidence. Yeah, and what we'll do is, as is customary, we'll have counter plaintiffs exhibits be numbers and counter defendants exhibits, if any, be letters, A through.
It's fine, Your Honor.
All right, so your first witness, Mr. Cleveland.
Gino D'Angelo, please.
Okay, Mr. D'Angelo, would you please come forward to the witness stand?
And just so I don't have to continually interrupt, Your Honor, can I just have a standing objection to relevance to this witness's testimony?
Yes, absolutely. Would you raise your right hand for me, sir? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you have to. All right, and the objection as to relevance is overruled, and it'll be considered as a continuing objection to this witness's entire testimony. All right, go ahead, Mr.
Thank you. May I stay seated, Your Honor? Is that okay?
Yeah, that's fine.
Thank you.
Your Honor, before, so I don't interrupt, can I take the podium so I can see the witness?
Yes, that's fine.
Please state your full name for the record.
Gino D'Angelo.
And how are you employed, sir?
I'm a real estate broker, self-employed.
So are you familiar with the Indian River area?
I am.
How so?
I grew up there.
What does that mean?
I was born and raised in Indian River. I still own a house on that side of the world. I sell a lot of real estate over there. I'm pretty familiar with Indian River.
And so does that mean you were also attending school in Indian
I went to
River?
River Lakes. I graduated in 2002.
And so what did you do after high school graduation?
I started selling real estate.
And did that require some kind of license?
I was licensed in 2003.
And just like that, the courtroom shifts into the testimony phase where every small detail suddenly matters. A 3-foot trespass, an anchor dispute, and years of bad blood between neighbors have now turned into a full-blown legal war. Sometimes the smallest property fights end up creating the biggest courtroom drama.